Good morning, everyone. It's the last day of our 3-day New Mexico Black Lawyers Association virtual social justice 101 lunch and learn. My name is Asia Brooks. I'm the president of the New Mexico Black Lawyers Association. Thank you so much for joining us. First of all, I'd like to give one last thank you to the City of Albuquerque's Office of Civil Rights for co-sponsoring this event, and to my awesome executive board of the New Mexico Black Lawyers Association. We have had some amazing speakers and thought-provoking topics, and that is all a result of your efforts. Some virtual housekeeping that we have to do. The sessions will be recorded. The chat function has been disabled, and the only video will be of the presenters and moderators. We will have a question and answer period at the end of the session. So if you have a question, please type it into the Q&A box and we'll try to get your question answered. Attendees will only be able to see answered questions. Today's presentations are approved in New Mexico for 1 hour of general credit CLE each. So if you would like to receive credit for both hours, you must attend both sessions. If you are an attorney or paralegal seeking CLE credit, please make sure to email your name and bar number to us at nmblacklawyers@gmail.com so that we can ensure you receive your credit. If you have already sent us your bar information, you do not need to do that again. So today's topics are hashtag Free the Hair, How Black Hair is Changing Civil Rights Law by Professor D. Wendy Greene, and she will be presenting until 12:30. And then from 12:30 until 1:30, we will have What to Do About the Equal Pay and the Gender Wage Gap in 2020 by Pamelya Herndon, Esquire. There is no need to log out between sessions. So that we can give most of our time to our speaker, I'd like to welcome her, Professor D. Wendy Greene. Just to preface what I'm about to say, this is just a snapshot of what Professor Greene has done. I'm just choosing parts of her biography to highlight. So Professor Doris Wendy Greene is a native of Columbia, South Carolina, and a graduate of Xavier University of Louisiana, where she received her BA, Tulane University School of Law, where she received her JD, and the George Washington University School of Law, where she received her LL.M. Presently, Professor Greene is the first tenured African-American woman on the Drexel University Thomas R. Kline School of Law faculty, where she teaches classes on constitutional law, employment discrimination, equitable remedies, real property, and seminars on race and American law and critical race theory, as well as appearance and grooming codes of discrimination in the workplace. Professor Greene's legal scholarship and public advocacy, which explores how constructions of identity inform and constrain anti-discrimination law, have generated civil rights protections for victims of discrimination throughout the United States. She is the architect of 2 new legal constructs recognized within anti-discrimination law theory and praxis: misrepresentation discrimination and grooming codes discrimination. Her internationally recognized publications in these areas have shaped the enforcement stance of the Equal Employment Opportunity Commission, administrative law judges, federal courts, and civil rights organizations in civil rights cases. Recently, the 11th Circuit and the 9th Circuit Court of Appeals endorsed Professor Greene's published definition of race as a legal authority on the social construction of race and as a practicable definition for constitutional decision-making, respectively. Moreover, the definition of race she proposed in her 2008 article, Title VII, What's Hair and Other Race-Based Characteristics Got to Do with It, is being adopted in history-making state and federal legislation known as the Crown Acts. The first laws in the nation to expressly recognize race discrimination is inclusive of the discrimination African descendants encounter based upon their natural and protective hairstyles, such as afros, twists, locks, and braids. I know that she was instrumental in getting the Federal Crown Act passed by the House of Representatives, and personally, I'm excited to hear her presentation since we are going to be presenting Crown Act legislation in New Mexico this upcoming session. Thank you for helping me welcome Professor Greene.
Okay, let's see here. Hi, good afternoon. I'll try to start the video again. Or not. Or I'll just go straight into the presentation. But thank you so much for having me this morning, your time, this afternoon, my time on the East Coast. And thank you, Asia, as well as Tori, for the invitation to present to the New Mexico Black Lawyers Association today. It's really quite a privilege and an honor to do so, and especially to be in collaboration around the civil rights legislation and advocacy more broadly with my fellow classmate, Tori from Xavier University in Louisiana. So I just want to say thank you so much again for this opportunity to share the work. A piece of work that is truly a huge part of my professional life. I have been advocating that natural hair discrimination is race-based discrimination for over a decade now, and it's really quite a privilege to be able to share this work with you today. So I will go and share my screen, and hopefully you guys can see it. All right. And I'll get started. So as Asia mentioned, a big part of my work has revolved around appearance and grooming regulations, and I've coined the term grooming codes discrimination that really reflects a specific form of inequality and infringement upon one's personhood, resulting from the enactment as well as the enforcement of appearance and grooming mandates or expectations, largely in the workplace, but it has extended beyond the workplace to education, public accommodations, and housing. These types of appearance norms, which we generally they're very common, but we often think that they're pretty harmless. They really are, in fact, very harmful in nature and do result in discrimination that implicate protected classifications like race, color, age, disability, sex, and or religion, among other characteristics that our civil rights laws protect. As Asia mentioned, I have published several publications here, and this is just a list of some of the key scholarship around appearance and grooming codes discrimination, where I've explored natural hair discrimination that African descendants suffer in workplaces, as well as the intersection of religious discrimination and racial discrimination that Muslim women encounter when they are donning hijabs. And also something that many people aren't aware of is that Black women too suffer pervasive discrimination when we are just donning naturally human or humanly natural hair colors like blonde hair. And so I too talk about that in my work, in particular, and Black women can't have blonde hair in the workplace. That being said, what the scholarship and public engagement for over a decade has really resulted in is what I have called the hashtag Free the Hair campaign or movement. And this movement really is inspired to increase public awareness around the systematic and global discrimination that African descendants suffer because of our natural hair texture and natural hairstyles like locks, braids, twists, bantu knots, and afros. And it too is trying to dismantle what we know as texturism, which is a race and color-based hierarchy that privileges straight hair because of its association with Eurocentrism or whiteness, and denigrates natural hair textures and natural hairstyles, curly, coily, kinky, however you want to describe it, because of its association with African ancestry or Blackness. And the ultimate goal of this public engagement, as well as my legal scholarship and public advocacy, really is to secure not only legal and social and policy change, but also personal change, so that African descendants and people of color more generally around the world can freely rock our natural hair or freely wear our hair according to our personal needs and desires. And so some of you are probably already very familiar with this issue in the contemporary sense. Just recently, Duke researchers just affirmed in a new study that Black women with natural hairstyles are less likely to get job interviews. And this is in comparison to Black women who wear straightened hairstyles, white women who wear curly hair, or white women who wear straight hairstyles, in large part because of this notion that straightened hairstyles are more professional and natural hairstyles are depicted or stereotyped as unprofessional. And again, this is rooted very much in a Eurocentric idea of what is attractive, what is professional, what is beautiful, what is the norm in society. And this translates itself or manifests itself in workplace decisions. We see many stories across social media. I'm sure if you talk to any Black woman that she can share a hair story with you. And these are just some that I've picked up from social media, where Jessica Powell, you see, is told that she has to keep wearing her wigs at work because they don't want to accept her natural hair because supervisors find it to be quote unquote distracting. So she is faced with either losing her job if she doesn't maintain a straight hair wig, or if she decides to rock her hair naturally, then she may very well lose her employment for which she is qualified and is, presumably effectively performing. You also see around the world where Black women have been told that they have to straighten their hair as a condition of employment. And one of the headlines up top talks about that in London, where a Black woman applied for a customer service position at Harrods, and she was told that she had to change her hair. In particular, she had to wear, get a chemical straightening or chemical relaxant in order to get her job. And we see this happening around the world, the stigmatization and this negative stereotyping related to Black women's hair. And this is just another example of it, where both of these Black women, one who is in Brazil, actress Thais Araújo, and then Deshauna Barber, who is the former Miss USA, where when they publicly donned their naturally curly hair, they were both likened to gorillas and monkeys on social media. Also recently, we have meteorologist Corliss Ortiz, who is an Afro-Latina, and she, as you can see, she has donned her hair straight on the air as well as curly. And when she decided to wear her hair curly on the air, one of the viewers contacted her and told her, to the weather girl tonight, please don't wear your hair like that anymore. It just doesn't look good at all. Change it back to something more normal, not something that's all inward iggery looking. So these kinds of dehumanizing racial epithets are very commonly targeted at Black women, pervasively targeted Black women when we are donning our natural hairstyles. And also you see through the enforcement of both formal as well as informal grooming policies and grooming norms that Black women's hair is often described as, or at least interpreted as, unkempt, disheveled, unprofessional, aberrant, radical, militant, unruly, distracting, wrong, extreme, unusual, unattractive, and unacceptable. And these kinds of stereotypes that are very much rooted in race, gender, and sometimes color really do not only stigmatize Black women in the workplace and beyond, but they end up really resulting in higher levels of harassment, higher rates of discipline, as well as denial and termination of employment opportunities for which Black women are qualified and or effectively performing. And it's unfortunate because this is not only happening in workplaces, but I'm sure many of you are familiar with the fact that this is also happening in our schools. And again, not to just say that this is only happening to Black women and girls, but a great amount of attention is being garnered around this issue because of some of the acute harms, which I'll talk about later, that Black women and girls are encountering when we are forced to adopt or comply with a straight hair mandate or expectation. And so these are just some of the stories that have been in the news as it relates to natural hair bans being enforced against Black girls. You see here at the top, those are 15-year-old twins at that time, Deanna and Maya Cook, who were issued detention because their protective hairstyles here were actually deemed unnatural according to the grooming policy at the school. And they were barred from extracurricular activities as well as from attending prom if they did not change their protective hairstyles or remove them. Additionally, we see here next under the twins, 16-year-old high school student Nicole Orr in Florida, who is wearing her afro here, and she was instructed to put her hair in a style, and basically implying that she needed to straighten her hair. Also, the same kinds of things are happening again around the world with Black girls in schools. In Melbourne, Australia, at the same time, we had 16-year-old twins, Grace and Tabisa, of Sudanese descent, who were pulled out of class and told that their hair did not represent the schools represent the school, and per the grooming policy, the sisters' braided hair was deemed extreme. Eventually, they did change their policy, but this policy is actually already stigmatizing these children's hair as something that is extreme and distracting and something that is wrong, and it is also infringing upon their rights to education. Let's see here. This is also happening. We've seen it in South Africa, where this is a picture of Zuleika Patel, who is a feminist activist already at a very young age. And I sort of call her the little Angela Davis here, because she, and along with her classmates, were protesting the regulation of their hair in their high school in Pretoria, South Africa. Zuleika had actually already been disciplined, severely disciplined, and expelled from several schools simply because of her hair. And you see here, this is where they are protesting publicly, which made international headlines in 2016. At the same time, all of these other incidents in the United States were occurring as well. And Black female students, current as well as former, reported that the school administrators counseled them to straighten or fix their natural hair with chemical relaxers and chastised them if the width of their braids was larger than a centimeter. In addition, we see some other types of really offensive and stigmatizing and frankly dehumanizing treatment with our students in schools. This is true story, and this is a true story out of Massachusetts in 2017, where she went to a weekend school, and there the school actually shaved her hair. And they claimed that it was because of hygienic reasons, and they did so without her mother's consent, to be clear. But what was informed, or what the mother was told, was that the volunteer told True that by shaving her head, her hair would grow back straight. And unfortunately, True is not alone in these really dehumanizing forms of treatment based upon one's hair in the school. In New Mexico, I'm sure you guys are already familiar with the fact that a New Mexico teacher allegedly cut off a Native American student's braid while calling another student of indigenous descent a bloody Indian. More recently, there was a school in Texas that took a young man out of his classes, told him that he was violating the grooming policy because he had these designs in his hair, and they forced the Black student to actually fill in the designs with a Sharpie marker. And then, of course, what really just reverberated around the world is Andrew Johnson's experience, where he had to cut off his locks or forfeit a wrestling match that he was participating in. And so really all of these things are really providing a really important spotlight on the systemic nature of natural hair discrimination, in particular, how natural hair discrimination is affecting overwhelmingly and disproportionately African descendants. And so I do have some good news with respect to this, is that some of us are probably very familiar with DeAndre Arnold's case, along with his cousin, Kaden Bradford. This too made international headlines, where DeAndre Arnold was told that he could not graduate or participate in his graduation unless he also cut off his locks. And his cousin, Kaden Bradford, similar to these other students, were pulled out of class. They were disciplined, they were isolated, put in school suspension, and then ultimately had to stop their matriculation at their high school because of the enforcement of a grooming policy that barred male students from wearing straight hair. Hair to their shoulders, or had the propensity to actually touch their shoulders. Because you see here, Kaden Bradford was actually wearing his hair up, and they still said that wearing his hair up violated the school's policy. But just recently, I served as a legal expert in this case that the LDF brought on the children's behalf. And thankfully, we had a very positive constitutional decision where the federal district court judge, informed by some of the historical and sociological evidence that I presented in the case, declared that they did have an actionable race discrimination claim, as well as a sex discrimination claim, and an actionable First Amendment infringement upon their cultural expression claim. And so I'm happy to report that. And some of the things that I talked about in this expert testimony is really trying to link this systemic discrimination on the basis of our natural hairstyles to the past, really placing it into broader historical as well as a global perspective. And one of the things that I shared with the court, and I talk about even in my work, is that natural hair discrimination is a long-standing form of racial discrimination, harkening back to eras of racial slavery and apartheid, not only in this country, but also in others. And this is a really important case that really clarifies this particular argument. And so in Hudgens versus Wright, which was decided in 1806 by the Supreme Court of Appeals in Virginia, this was a freedom suit. And 3 women claimed that they were wrongfully enslaved because they were of indigenous ancestry. And at that time in Virginia, in Virginia, the law was that our status would be determined by our maternal line. So basically, whether we were free or enslaved would be determined by the status of our mother or our grandmother or great grandmother and so forth. And also in Virginia law at the time, indigenous peoples were no longer able to be enslaved. So thus, the only group of individuals who could be subject to enslavement were African descendants. And so they claimed that they should be free and that they were wrongfully enslaved because they descended from a woman by the name of Butterwood Nan, who was reputed to be, reputed in the community to be indigenous as well. And so what the court said is that as they are seeking their freedom, they said how we are going to really figure out whether or not individuals who are coming to us who are whether or not they're free or slaves, essentially, that it's not just simply about your skin complexion, but also about your hair texture that marks you as either European descendant, as African descendant, or indigenous. And so here they tell us that nature has stamped upon the African and his descendants 2 characteristic marks besides the difference of complexion: a flat nose and a woolly head of hair. And in comparison to African descendants, whites or European descendants would display brown hair, not woolly nor inclining thereto, among other physical characteristics. And so what the court basically tells us is that, our hair texture could easily mark you as Black and therefore enslavable. And alternatively, would mark you as white or indigenous and therefore free. And so our hair texture has long served as a critical site of external racial classification, as well as internal racial classification. And these physical constructs that were outlined, even in that case in 1806, continue to shape our understandings of racial identity today. Also in the 20th century, curly or more coiled hair texture served as a legal basis of racial exclusion and subordination in the United States, as well as in South Africa. During South Africa's regime of apartheid, the South African government even used what is known as the pencil test to determine an individual's race when that person's race was being challenged. And I just want to show you a very quick depiction of this pencil test that was performed in a real case of racial identity determination, where we have Sandra Lang, and this is from a movie called Skin. And Sandra Lang, she too was expelled from her school in 1965 because they perceived her as being colored, and she was in an all-white school, and basically her racial identity as white, which was what was on her birth certificate and what her parents classified her as you can see, they phenotypically appear white, was being challenged. And one of the ways in which they were going to determine her identity is by engaging in this physical examination, including the pencil test. And I'll just show you a clip of that. Take a seat, please.
No.
Sandra Lang.
What's your relation?
We're her parents.
Take a seat. Excuse me. Sandy.
Thank you. Will stand.
The definition of a white person is a person who in appearance obviously is a white person and who is not generally accepted as a colored person, or who is generally accepted as a white person and is not in appearance obviously not a white person.
Is that clear? Come. Shake your head. Harder. Turn around. Stop. All the way. Open your mouth. Show me your teeth. Thank you. You may go. Wait.
So what that depicts for us is the ways in which we have been physically examined in order to determine our racial identities, and that determination of our racial identity, inclusive of examining our hair, is really quite critical and has always been quite critical, starting back with eras of racial slavery, and as you can see during the eras of racial segregation in South Africa. And what was really important about that is not only with that racial determination assist her in terms of what school she could attend, but if she was classified, which she ultimately was, as colored, she and her parents would be violating the law by virtue of living together, because at that time individuals of different racial identities could not live in the same home or otherwise be criminally charged and be subject to imprisonment. So you can see how very critical not only the determination of racial identity more broadly, but how critical our hair texture has been to that determination, and thus to our exercise of freedom, our exercise to engage in different forms of even familial relationships, as well as the ways in which we are able to enjoy certain privileges and employment privileges in our employment, as well as other spaces. So here in the United States, at the same time as this is going on in South Africa, and racial apartheid is existing in South Africa, we too are trying to challenge racial segregation in the United States. At that time, we have the Civil Rights Act of 1964 that was passed in order to dismantle racial segregation and other forms of discrimination in our workplaces and other spaces. And this is where we start to see the start of cases that that Black women were bringing, in particular, challenging workplace grooming policies that barred them from wearing natural hairstyles. And this is Deborah Renwick, who was 27 years old at the time and was working for United Airlines. And as you can see, she was wearing a fairly short fro, and she was actually placed on a 21-day suspension, and she was ultimately fired because she refused to change her afro. And according to the United Airlines, her afro did not comply with the company's quote unquote short hair look. Deborah Renwick is not the only person challenging natural hair discrimination as race discrimination in these early years after the Civil Rights Act was passed. Renee Rogers is also one of those women. That's not her featured, but I could not find a picture of her, but nonetheless, she was wearing a cornrow braided hairstyle, and she too served as a customer service agent for 11 years with American Airlines. And she likewise was told by American Airlines that she could not wear her cornrow braided hairstyle because it violated their grooming policy that mandated a professional and conservative image. So basically what American Airlines is telling her, like so many other Black women when we're wearing our natural hairstyles, that her cornrow braids were unprofessional and not conservative. What was interesting about this case, which is a very seminal case, is that she claimed that this ban impacted her specifically as a Black woman. So she brought an intersectional claim of discrimination, and she argued that this prohibition against braided hairstyles was discrimination on the basis of race and sex in violation of Title VII of the 1964 Civil Rights Act, Section 1981 of the 1866 Civil Rights Act, as well as the 13th Amendment. And what the court did in this case, why I even mention this, is because they ultimately held that her claim for sex discrimination was unactionable because Black men too could be subject to this grooming policy that barred natural hairstyles, and that white women likewise could not. And so they also said that her claim was not about race because white women too could potentially be subjected to this ban against braided hairstyles. They even go on to intimate that Renee Rogers, even though she argued that natural hairstyles were a part of a cultural tradition and norm within for African descendant women, they basically, and I'll go back just really quickly, they basically said, debunked that and refuted that, rejected that whole notion, and said, and sort of implied, not even sort of, they did imply that, she was wearing braided hairstyle likely because Bo Derek had recently worn a braided hairstyle in the movie 10. So it's this idea that her muse was a white woman and not a result of, an intergenerational tradition for African descendant women to wear braids. And in that case too, so they ultimately declared that braided hairstyles did not or discrimination on the basis of braided hairstyles did not constitute race discrimination. However, they did carve out an exception where, according to this immutability doctrine, which I'll talk about in just a second, that they thought that, if you discriminated against on the basis of an afro, then that would be considered race discrimination because of this notion that afros were an immutable racial characteristic of Blackness, or in other words, that only Black people can don afros, or to the extent that you don an afro, you are of African descent. And so this really harkens back to what was just talked about with the Hudgens versus Wrights case, that this woolly or afro-like hair texture is indicative of African ancestry or Blackness. And today, this immutability doctrine and its consequences continue to shape our federal jurisprudence on this issue. Just recently, a federal judge ruled that a petition that was being circulated around the workplace that a Black woman's natural hairstyle was unprofessional, was offensive, but it did not amount to a racially hostile work environment. More recently, in the 11th Circuit case, EEOC versus Catastrophe Management Solutions, the 11th Circuit reinforced this immutability doctrine in its decision around a case involving this Black woman, Chastity Jones, who was told that she had to cut off her curly locks or her blonde locks as a condition of employment. And what the HR manager told her at the time is that, I'm not saying that yours are, but they tend to get messy. You know what I mean? And I always say that Chastity Jones says, no, I don't know what you mean. And she gave back her paperwork, and she went to the EEOC and filed a race discrimination claim. And so the EEOC brought this case on her behalf, and I'm basically challenging the enforcement, again, of a grooming policy that bars excessive hairstyles, as well as mandates that employees project a professional and business-like image while adhering to company and industry standards and our guidelines. So effectively, once again, through this enforcement of this policy, mandating that Ms. Jones cut off her locks, again, we have a employer telling an employee, and in particular a Black woman, that her natural hairstyle is unprofessional, it's not business-like, and it's unacceptable. And it disqualified her from a job opportunity for which she was qualified. And so basically in this case, what the court does is that they once again apply this immutability doctrine that was adopted in Rogers versus American Airlines, but they go on a little bit further. And they tell us that discrimination, or race discrimination in particular, is is only going to result from discrimination on the basis of characteristics with which you are born, characteristics that you cannot change or are difficult to change. They further, and I call this a hair splitting distinction because that they create here is because they say discrimination on the basis of a Black hair texture, which they deem is an immutable characteristic, is prohibited by Title VII, whereas adverse action on the basis of a Black hairstyle, a so-called mutable choice, is not. And so what that ultimately means is that they are describing afros as a Black hair texture and an immutable characteristic of Blackness. And so if you discriminate on the basis of an afro, then that is race discrimination. But if you lock, braid, or twist that afro, then magically it no longer has anything to do with race. It's about culture. And since Title VII does not prohibit discrimination on the basis of culture, employers are not violating our federal civil rights laws, and they are free to regulate our natural hairstyles. And so I argue in the work that this immutability doctrine is very much grounded in biological notions of race, that we need to expand our understandings of race as a social construct when we are enforcing our civil rights laws. It is also a legal fiction because it's based in a fictional idea that only Black people have afros, or to the extent you have an afro, then you therefore must be African descendant. We know others who do not identify as such who are rocking afros. It also perpetuates a racial hierarchy that privileges straight hair, which is associated with whiteness, and denigrates naturally curly and coily hair texture associated with Blackness. And it in turn legalizes the hyperregulation or policing of African descendant people's bodies through the medium of our hair, a practice that harkens back to eras of racial slavery and racial apartheid. And in particular, as it relates to Black women, what it does is it basically allows for a straight hair mandate or expectation in our workplaces and other spaces that we have to conform to. And a lot of people don't really understand what it means to conform to the straight hair expectation or mandate. So many of you may be aware that in order to comply with it and the pressures to straighten our hair, that we are using chemical relaxants that are very toxic starting at very early ages. As you see here in the picture, we're using extreme heat styling as well as through straightening combs and other straightening agents that can sometimes reach to 450, 500 degrees Fahrenheit that we're placing on our hair as well as in our scalps. And that we are also using very damaging wigs and weaves in order to conform to a straight hair expectation or norm. And in light of all of the things that I've just talked about, you can understand how the Perception Institute's Good Hair Study found that 1 in 5 Black women feel social pressure to straighten their hair for work, twice as many as white women. We're experiencing greater levels of anxiety about our hair. And we also are reportedly spending 9 times more money on professional hair styling and hair products and more time on our hair than white women. Additionally, to sort of conform to these straight hair expectations and mandates that not only in our workplaces, but in other spaces, we are losing our hair. We are suffering permanent as well as temporary hair and scalp damage, as well as other medical conditions due to chemical burns and scarring and abrasive hair products and hairstyling techniques. And as you can see here on the left, those are pictures of the results of alopecia. And we're also spending money and time and energy to repair the harms that we are suffering when we are trying to conform to these straight hair expectations and mandates. Additionally, when it comes to our health, there are studies that link the development of increased rates of uterine fibroids, uterine cancer, hormonal infertility, and breast cancer to chemical relaxants and other hair products that we're using to maintain straight hairstyles. Also, as it relates to Black girls, there are studies that indicate a potential correlation between these hair products and increased hormonal activity among Black girls that may then generate some of these medical conditions that we are talking about. Additionally, 3 times as many Black women have reported that they disengage in exercise and other physical activities solely because of their hair. Black women are not going to oftentimes exercise after we have spent a lot of money and time in order to straighten our hair. And that then can lead to problems such as obesity and other medical conditions that flow from it. So basically, basically what our federal jurisprudence does, it fortifies this unthinkable catch-22 for Black women as well as girls that either, you pursue educational employment opportunities at the risk of harming our emotional, physiological, psychological, and economic well-being to do so. And what I often say when talking about this issue is that if you say you care about Black women's health, then you have to care about our hair. And so to address all of these things that I've talked about, as Asia mentioned, I did offer a definition that could be included and be used when we are enforcing our civil rights laws, and that race should be viewed beyond immutable characteristics and as a social construct that it is, and that should be inclusive of physical appearances and behaviors that society historically and presently and commonly associate with a particular racial group, even when those appearances and behaviors are not uniquely or exclusively performed by or attributed to a particular racial group. And as Asia mentioned, this definition of race has been adopted in Crown Acts and in the original Crown Acts of California, New Jersey, and New York. You'll see where the definition of race is historically associated with race, including but not limited to hair texture and protective hairstyles, and specifies that protective hairstyles includes but is not limited to such hairstyles as braids, locks, and twists. And this statute is applicable to both workplaces and schools. And since then, 7 states have enacted the Crown Act: Maryland, Colorado, Washington State, New Jersey, New York, Virginia, and California. And municipalities have have adopted the Crown Act or versions of the Crown Act through ordinances. And these are just a list of those. In addition to this legislation, I think it's also important to note that there are enforcement agents, human rights enforcement agencies that too have issued really groundbreaking guidance as it relates to natural hair discrimination, and declaring natural hair discrimination constitutes race discrimination in workplaces, public accommodations, as well as private schools, private and public schools in the case of New York with the New York City Commission on Human Rights, and then also as it relates to New Jersey, the Office of the Attorney General there also issued enforcement guidance on race discrimination based upon hairstyles. And so again, as Asia mentioned, I had the privilege of co-drafting the Federal Crown Act and also some other state level Crown Acts, including right now working on Georgia, and I've worked with legislators in South Carolina, and also provided guidance with legislators in Maryland and in Philadelphia, and so, or in enforcement agencies too. I'm sorry, in Philadelphia. And so, if the Federal Crown Act is passed by the Senate and signed into law by the President, what it would do is clarify that race and national origin would constitute characteristics commonly associated with race and national origin, and it would apply to workplaces, housing, public accommodations, and federally funded institutions. For the lawyers who are on the line, I thought you also might be interested to know that the ABA has recently adopted a resolution that endorses the Crown Act, as well as enforcement agencies viewing race as characteristics, physical and cultural characteristics associated with race, and that they too are endorsing exactly what's going on right now, training as it relates to appearance, style, texture of a person's hair in our anti-bias training, and also to really try to encourage employers to carefully review their discrimination policies, to attend to discrimination on the basis of appearance, inclusive of natural hair discrimination. And so basically what all of this does is it really dismantles centuries of legal, lawful discrimination, if you will, on the basis of race, animated by our natural hairstyles that African descendants have experienced globally. The Crown Act, in addition to other legal reforms are also attending to nearly 40 years of federal precedent that permitted the lawful deprivation of employment, education, housing, and access to public accommodations on the basis of this race-based characteristic. And ultimately, it clarifies that all forms of discrimination are animated by perceptions, biases, and stereotypes associated with both mutable and immutable characteristics. And it is not giving special treatment to African descendants, but really what it's doing is bringing about equal treatment for everyone who suffers from discrimination on the basis of their appearance. And ultimately, in this context, what all of these legal reforms are doing is really freeing the hair. And I will stop there.
Thank you so much, Professor Greene. That was so fantastic. I literally went to go pick out my hair some more. I thought it was a perfect talk. We've got a couple of questions in our Q&A. Our first question is really around more of a what can be done in support of Black women if they're a Black female attorney and a jury consultant comes back and says the jury panel is concerned about a lawyer's afro. What can be done in support of that attorney and the client?
Oh, can you go back a little bit? I'm sorry, I saw a question. So could you repeat that? I'm sorry, just really quickly.
Sure. So there's a jury consultant who says that the jury is concerned because the Black female co-counsel has an afro. What can be done in support of that Black woman?
Oh boy. So the Black woman lawyer is wearing an afro and they think is going to have a negative effect. Well, I mean, that is a real—
The jury comes back and says it's radical.
Oh, it says it's radical. Well, you know, that may very well be true, that may happen, but at the end of the day, I don't think I mean, you can tell her that, but I don't think, again, the solution is to force that woman to have to cover her hair or to straighten her hair, chemically straighten her hair, or do it with heat styling techniques if that's not what she wants to do. You know, ultimately, the hope is that they can get beyond their own stereotypes and biases and stigmas as it relates to her hair and really focus on what she is doing in the courtroom, right? And whether or not she is effectively representing that client. And sometimes, you know, this is one of those things where for that attorney, and I know this may lead to some levels of vulnerability, if you believe that perception, and it's a very rampant and pervasive perception, may end up influencing the jurors, it may be a level of education, and it may just be something that you might have to speak to when you are doing your opening argument or your closing argument, you know, to try to sort of diminish and sort of call out, sort of implicitly or maybe even explicitly call out the particular bias that might be operating. And I say that because even if you did change your hair, it may not still change the person's perception of you as being radical, right? Just by virtue of your skin complexion, right? That you might be perceived as radical or that you don't belong in that space or incompetent, but we're not going to have anybody change their skin complexion. So I just think that we have to start probably being a little bit more explicit in confronting those biases head on if we do really believe that they will actively shape certain types of stereotypes and stigmas and ultimately decision making. But I don't believe that we should be encouraging people to do all of this contortion in order to try to fit into some kind of really like fictional norm. So every time that, you know, and then another part of that is that then infringes that person or potentially impacts that person's self-confidence and their self-esteem, and can then have a negative impact on their performance as they are doing their job because it's not normal or natural to them. So that's something else. You know, I think that we really have to encourage people to show up as their most authentic selves. And I know that's challenging, but that would be my answer to that.
Perfect. And we've got a follow-on and the questions are coming in. So as a follow-on, do you have suggestions on how to address it during jury voir dire?
as it relates to the lawyer, or as it relates to or picking or selecting a juror? Because I will tell you, it has happened in the latter case. And it's actually brought, ended up generating constitutional or Batson challenges. And there are some, yeah.
Yeah, no, just a follow up from the question asker, for purposes of striking potential jurors.
Oh, wait, don't do it. That's what I would say. Don't do that. And I say that, and I'm not trying to give legal advice. I'm just saying, based upon my research, that there have been constitutional challenges to striking a juror on the basis of their natural hairstyles. And there are some state courts that have treated that as racial discrimination. And
But what about in the reverse? If
in the reverse,
question to the juror and they comment that they're uncomfortable with.
They're uncomfortable. Well, if you have time, I think we have to sort of interrogate that and figure out why they are feeling uncomfortable about my natural hairstyle versus and what is their alternative to that. Do you want me to wear a wig? Do you want me to cover it up with a wig? Are you asking me to cut off my hair? I think it's important to have that conversation to really get that person to explain where that uncomfortability is coming from. And then trying to help them sort of become debiased in that moment. It's not to say that that's going to happen. How much we engage in anti-bias training, but I think you really probably have to speak to it in that moment and really try to get that person to figure out that, again, that has absolutely nothing to do with their treatment or that person's ability to do the job.
We've got a number of people who are attending the webinar today who are members of the Pass the Crown New Mexico. And we got a question coming in from one of the members of the committee. What tips would you give those of us working to get the Crown Act passed in New Mexico? We have heard things like, does this even happen here? Or this won't pass unless you include Native brothers and sisters, because we only have 2.8% of a Black community here in New Mexico.
Right. Well, I think it's important to really show how, even though this legislation is very much centered around the African descendant experience, that it's not only affecting Black people, that there are Indigenous peoples who are being subject to offensive treatment, stigmatizing, dehumanizing treatment as it relates to their cultural hairstyles, like their braids, for example. One of those examples I put in the slide as it relates to the student whose braid was being cut, and it was apparent, or at least according to the allegations, that it was very much generated by racism against Indigenous peoples, right? Very specific and targeted racial bias as it relates to Indigenous people. So I think that it's important to show sort of the commonality in experience as it relates to cultural hairstyles that are associated with race or national origin or culture, depending if you have culture in your legislation, and that is not just African descendants who are suffering this kind of discrimination and stigmatization in our schools and in workplaces, but others as well. So I think that would be very important to speak to those experiences, and even in terms of situating it in terms of a broader historical context, is that we know that Indigenous peoples were forced to cut off their hair in order to attend certain schools, also and more broadly to assimilate into American society, right? So you can also bring in that historical context to demonstrate the ways in which this suppression, if you will, of our cultural identity is affecting people of color, broadly speaking. Then lastly, to that point, what I think is really important for legislators, as well as the broader public who may be sort of opposing the legislation or thinking that it's only going to protect one group of people. The fact of the matter is going to end up protecting everybody who is suffering from discrimination on the basis of mutable characteristic, not just hairstyles. even though that's a very central component of it. But for example, like I mentioned, if you have a Black woman who is donning blonde hair, right, and is told that she can't wear blonde hair, but white women are able to wear blonde hair, it's going to protect that woman. Similarly, if there is a white woman who's wearing a braided hairstyle, for example, and Black people are able to wear braided hairstyles, but she's not, then that too will, she too can bring an actionable claim of race discrimination. And there are also other things in terms of like language and accent too, which are mutable characteristics that individuals are discriminated against in our workplaces and other spaces that too are associated with race and national origin and culture that would fall within this definition that is being proposed. So yes, the focus has been on hair, but this definition will definitely be able to protect against discrimination on the basis of mutable or changeable characteristics that are linked to these protected classifications, and ends up protecting everyone who may be suffering discrimination on those grounds.
That's wonderful. I just have one follow-up question, and then I have another question that I'll end up posing to our Black Lawyers President. But Professor Greene, I know that this has been moving. You mentioned New Jersey and California, but some states have not passed the Crown Act. Do you know some of the reasons why they're not moving in some jurisdictions and some legislators?
Sure. Well, one in particular, it was in Oklahoma where it was passed, but the governor vetoed the Crown Act, even though it had really overwhelming public support and legislative support. And what was interesting about that, he gave the reason was that he wanted to work with the legislature to ensure that the statute made it where unlawful discrimination was limited to discrimination on the basis of immutable characteristics. Go figure, right? So you're basically maintaining the law, the status quo as it is, right? So part of that is because of, again, that idea that race is something that is immutable, it's something that is biological, that discrimination on the basis of race should only be limited to something that you cannot change, like your skin color, arguably. And so that very like constrained and constricted notion of racial identity and race more broadly does oftentimes shape not only, as you can see, federal judges, but also even our legislators and leaders. And so that's one thing. Another thing that I know, COVID happened, so there's that. So a lot of states had actually introduced the bill last legislative session and had to really kind of stop, their activity around it, and are going to reintroduce it in the coming legislative session. So there's that. There are some other folks too who are very unfamiliar, many folks who are very unfamiliar with the issue and think, that this is something that's, this is all in your head kind of thing. This is not really happening. So I do think that the greater levels of stories and narratives around natural hair discrimination, as well as other forms of discrimination on the basis of mutable characteristics that people are experiencing, need to be illuminated and being shared. And lastly, I will say is that what I found sometimes is that legislators, if you call, say, natural hair discrimination, race-based discrimination, or racial discrimination, how they may perceive that is like, well, if I don't like your fro, if I don't like your braids, that you're basically charging me with being a racist. And people are very uncomfortable with that, right? And they're uncomfortable with the idea of possibly perpetuating white supremacist ideologies. And then therefore you are calling me a white supremacist, and that's not what you're saying. Really what we're saying is that you're engaging in a long-standing form of racial discrimination, centuries-long form of discrimination and biases and stigmas that are associated with our natural hairstyles. And that's whether consciously or unconsciously. And if we're really trying to bring about greater levels of substantive equality and inclusion and belonging in our workplaces, we have to dismantle those things. And so that's something else that I've seen. So, there are lots of different reasons, but I definitely do recall that being one of the critical sort of responses that I have observed.
And Professor Greene, one last question, and then the next one I'll pose to Asia. Are there race neutral appearance requirements related to hair that would be okay for an employer to require?
Sure. So in this context, I think again it'll be sort of limited in terms of say natural hairstyles. One of the kind of compromises, if you will, is that if it does, and you can demonstrate that that person's hairstyle would infringe upon their safety, or would impair their safety. But even with that, the idea is not to cut off or mandate that they cut off their hair, but rather to accommodate, right? To bring about this accommodation principle, and to be able to come up with some solutions to that, like possibly pinning it up or putting it in a head covering or a head wrap while you may be working around, say, machinery, for example. But outside of that, I really can't think of any other reason as to why you would need to regulate to the extent to have to force someone or compel someone to cut off their hair or to permanently alter their hair as a condition of employment or to maintain employment. So I think people have to be very careful about these kinds of race neutral descriptions in their grooming policies, not simply, because I know we think, oh, well, it's okay to just say it's professional, or we are mandating professional or presentable or acceptable hairstyles, hair colors, and things like that. On the surface, it may not be harmful at all, but the ways in which you may enforce them, right, can end up being disparate enforcement and end up targeting particular individuals. And you're giving a lot of discretion to individuals to be able to shape decisions and discipline and ultimately possibly employment opportunities and educational opportunities based upon their conscious as well as unconscious stereotypes and biases. And so to sort of cure that, I think you have to be very, very careful in sort of limiting, regulations around appearance to those things where and you have evidence that it will impair somebody's safety or a third party safety.
Thank you so much, Professor Greene. Everyone, join me in thanking Professor Greene for honoring us with her time. I turn it over to President Asia Brooks. And Asia, there's a question in the chat that I think you would be able to talk with us about briefly, which is, what's the status of the New Mexico Crown Act? Is there a draft available? Thank you again, Professor Greene.
You're welcome. Thank you.
All right, so just to answer the question posed, we have done some presentations on the Crown Act New Mexico to some interim committees. There is a draft available. There's also a fact sheet that the Crown Act committee has put together. And so if you are interested in any of putting this forward during the legislative session, it will be put forward during this legislative session. You can get a hold of me. You can email us at the nmblacklawyers@gmail.com email. We're very excited about this. The Crown Act Committee has really been doing a lot of work around this. And I'm really encouraged. And one of the things that Professor Greene said that I think is really important is that this legislation will protect everyone. And we always hear that in New Mexico, Black people are only, 2.8% of the population. Why should we listen to you, right? But why should anyone have to deal with discrimination from the hair that is natural to them? No one should have to deal with that discrimination. So is it really so bad that we're trying to prevent discrimination against African people who have over centuries have been told that their hair, is a problem? When should we really be doing that when, hair is not what defines a good worker? Hair is not what defines good school performance. That shouldn't even be part of the conversation. So really, we've had to deal with that narrative of, you're only 2%, you're only 3% of the population. Why should we care? Because we are part of the population, and discrimination is bad. Hair discrimination is here. African American people who live here have experienced it. And so it's definitely time for this legislation to be passed. So that's just my little soapbox, sorry. I wanna get to the next presentation, and I wanna thank Dr. Greene for her time. Thank you so much. This was amazing. We're really excited and moving forward.
Oh, thank you so much. And if you need any assistance, you know how to reach me. I'm happy to help in any way that I can. And I just want to commend you all for this amazing work that you're doing in pushing this important legislation forward.
Definitely. Thank you so much. And now we're going to go into our next presentation, which is what to do about equal pay and the gender wage gap in 2020. This will be presented by Pamelya Herndon, Esquire. So I'm going to say a little bit about Ms. Herndon. Pamelya Herndon currently serves as the president, CEO of the KWH Law Center for Social Justice and Change, a nonprofit law center focused on providing access to justice for low and medium income individuals with an emphasis on advocating for the rights of women, children, and families with children. Pamelya is a graduate of the Howard University School of Business and the University of Texas School of Law. She is licensed to practice law in the states of New Mexico and Colorado. She is also licensed as a certified public accountant. Pamelya is a 2019 to 2021 W.K. Kellogg Fellow. She serves as secretary of the board of directors of the U.S. Eagle Federal Credit Union and as first vice president of the NAACP Albuquerque branch. She is a member of the Council of the American Bar Association Civil Rights and Social Justice section. In addition, she has been appointed to the ABA Commission on Domestic Violence and Sexual Assault. Pamelya serves as the chair of the AAUW Public Policy Committee, where she leads the team in advocating for fair pay for women. Pamelya has been recognized as the Public Lawyer of the Year by the Public Law section of the New Mexico State Bar, as the Lawyer of the Year by the Albuquerque Bar Association, and she has been featured in Essence Magazine, an international publication, as one of the outstanding lawyers providing policy and advocacy legal services to low-income individuals. Thank you, and help me welcome Pamelya Herndon. You are muted, Pamelya. There
So
we
I
go.
should know better than that. You know, I've been on like 20 million Zooms in the last few days, and you think I would know. But, you know, in talking to my son and my family, we have absolutely determined that we are going to get a shirt, and it's going to say you're on mute, and you just wear that all the time. But in any event, it is absolutely great to be here with you all and to talk about an issue that is extremely important, and that is with respect to equal pay for women. And so I do have a PowerPoint that I want to share with you as we have a conversation today about this very, very important subject. So we're going to get this slideshow moving from the very beginning and share it with you. And as I work in my nonprofit law center, we're really surprised to see that we are in this in the year 2020, and yet we are still seeing evidence of unequal pay for women. But before we go there, we just want to tell you all that we hope that you are staying safe and that you are social distancing during this period of COVID-19, because we need you around, every last one of you, the good sisters and the good brothers fighting for fair pay and equal pay for women. So we are going to talk about what to do about equal pay and the gender wage gap in 2020. So we're looking at women and the things that are happening with respect to them, even during this COVID-19 period. And we're finding that women are definitely undervalued, underpaid, and under siege. And so we need solutions to equal pay for women all over the country, and particularly right here in New Mexico. So what I'd like you to do is, as we continue with our discussion this afternoon, and Asia and Sonia are going to help me keep tabs on the time so that we can make sure we have enough time left to have a conversation with you about any questions that you may have. So there's a chat box. Make sure that you put your questions in the chat box, And if you are on the phone and you're not using a computer, I have listed my email address there for you so that you can email me with your questions and we can have a conversation offline if for some reason we don't answer your question during our presentation today. So as most of you may know, the year 2020 is the year in which we celebrated the 100th anniversary of the year that women got the right to vote. And it took women 72 years to get that 19th Amendment passed so that they could get the right to vote. So we said, surely when women got the right to vote, there would be lots and lots of other equality options that would come along with that. One of those being fair pay and equal pay for women. But something has gone wrong. And whatever that something is, we're going to talk about it. And I'm going to provide us with a 5-point strategy that I and the members of my law center have come up with so that we are absolutely moving toward equal pay for women all over the country. And we are not waiting 72 more years, 22 more years, but we want equal pay and fair pay now. And so let's sort of talk about a little bit of history and how we got there. And why is it important to talk about history? Because we don't want to ever repeat it again, particularly when it's not good. So there were two major pieces of legislation that passed during what I call the equal pay movement between the time that the 19th Amendment was passed and today. And so those two pieces of major legislation are the Equal Pay Act of 1963 and the Civil Rights Act of 1964. And let's just look at them, what they were supposed to do and what they are not doing and how we need to fix it. So the first thing that we see when we look at the Equal Pay Act of 1963, we talk about it being a federal piece of legislation. And the purpose of that legislation was to prevent pay discrimination based upon sex. And employers were not allowed to pay men more than they could pay women, particularly when they are doing the same or similar jobs. And employers must consider, are these individuals absolutely doing the same or similar job? And if they are, you cannot pay them separately. But what we found is that there's a loophole in the Equal Pay Act. And so I call them loopholes, but others call them reasonable opportunities for an employer. So let's look at what those loopholes that I describe are. So they are seniority, merit pay, and productivity. So I'm going to talk about those three first, because what can happen is that an employer can indeed pay men and women differently based upon seniority, on merit, and upon productivity. And if we talk about merit for just a moment, we see this happening this concept being utilized a lot in the university and educational setting, because when there's a differential in pay between men and women, what we hear often stated as well, the man has written more, he's produced more, he's been traveling around the world more. Well, I think that that's all admirable, but we also want to make sure that women and what they have been producing and providing to the university setting and to an education setting has been considered, because those things are important, and not necessarily traveling around the world, but necessarily building up the university and educational area where they preside. And with respect to seniority, we really push back on that, because a lot of times women will leave the workforce for the purpose of taking care of children, their family, or for an elderly family member. And so when they come back, of course, their seniority has been diminished somewhat. And why are we punishing them? Because they took a moment to take care of their family and to make sure their communities are lifted up with the well-being of their children and their families. And productivity. So we sort of look at that also in terms of why is that necessarily a reason for making sure that there should be a differential in pay between men and women. because there could be lots and lots of options and opportunities that come available to some that are not available to others with respect to that productivity. But the big barrier of all is the fourth provision that is listed in the Equal Pay Act that will allow for any other factor other than sex to be considered. And that is the factor that has been the most challenging, preventing or providing rather the most barriers, allowing for employers to have a differential between the pay that is given to men and women. And we're going to talk a little bit about a piece of legislation that is now sitting on the floor of the United States Senate, and it has been sitting there for far too long, more than 6 years, waiting to get passed, that would take a look and put an end to that fourth provision on a federal level of any other factor other than sex, which has definitely been a reason utilized in many court cases that has prevented this inequality from coming to equality. So let's look at what absolutely happens with respect to the Equal Pay Act. And what we find is there are some really great points about that act. Number one, it was enacted, but number two, when there is a discrepancy in pay and you see people are doing the same or similar work, then if an employer is paying them differently, the employer must increase the employee with the lower wages. They cannot decrease the wages of a higher paid employee and say, well, I brought them under the same umbrella, and so now they are earning the same. So no, some have tried, but that is not the purpose of the act, and that is not what was intended with respect to the act. So then we go to look at a piece of legislation that was enacted just 1 year later after the Equal Pay Act of 1963. And now that was the Civil Rights Act of 1964. And what's special about that with respect to the issue of fair pay and equal pay? Well, number one, it is included and Title VII of the 1964 Civil Rights Act is a major provision that has been utilized to allow individuals who say they are not being paid equally to utilize that provision to seek equal pay. And what have we found as a result of those claims that have been encompassed under Title VII? Well, when you file a claim under Title VII, you absolutely must go through the EEOC and their processes, that is the Equal Employment Opportunity Commission and their processes before you can file suit in court. So there must be a determination by the EEOC that they can not settle the matter for you in the manner in which you want. So they will give you a right to sue letter. So that's a long process. And so what we feel that a woman who's already not being paid fairly to have to go through this arduous process that looks like a court case, and before they can even get to the court case is a really difficult barrier for someone to overcome when they're in need of money now and they're not being paid fairly. And let's just sort of look at what else happened with respect to that Title VII provision with a woman named Lily Ledbetter. Now, many of you know, and I know you've heard of her, Lily Ledbetter worked for Goodyear Tire and Rubber Company. And so Lily thought she was being paid really well. She says, oh, I'm doing good, I'm here, I'm fine. Until there was a man who left the employment of Goodyear, and he said to her, hey, Lily, you know what? You're not being paid the same as the rest of us guys were being paid, even though you were doing the same or similar work. And Lily said, what? I can't believe this. I've been such a good employee. So she looked and she investigated the matter further, and it absolutely was true. She was not being paid the same. So Lily brought a case. And what the court determined in that case is that Lily's time had absolutely expired for bringing her case. They said that her responsibility was to have brought the case when it was first determined, or when the first evidence of fair or unfair pay was absolutely rendered to her. And she said, how could I do that when I didn't even know about it? And so the Supreme Court said, well, you know what? That doesn't matter. That's the ruling that we're coming up with. So Lily Ledbetter, you just lose on this one. Well, then guess what? Along came the person, the white knight riding his horse in, and his name was President Barack Obama. And so he signed in 2009 what was known as the Lilly Ledbetter Fair Pay Act. And what did that act do? That act said that the statute of limitations does not begin to run until the person actually learns about their unfair pay. And then it begins to run, a new statute of limitations runs with every single check that a person receives that is a check that is evidence of their not being paid fairly and equally with a man doing the same or similar job. So we were happy about that. What we've been able to do is we do our research and we look at this concept of fair pay. We are finding that most states really do have some aspect of wage discrimination within their laws and the application of their laws. But let me tell you about 2 states that don't. And can you imagine and guess what those 2 states are? So if you're the first one to put those 2 states in the chat box when I look at it, I've got a special surprise for you. But in any event, those 2 states are Alabama and Mississippi. Now you had to put that in before I gave you the answer. So I had to look at my watch and see what time that was so I could compare it with when an answer was absolutely put in the chat box. But in any event, we are needing to look at a way to make sure that Alabama and Mississippi come on board and are taking care of the women that are in their state and giving them the same opportunity through some state provision that may go beyond the Equal Pay Act of 1963 that will provide a greater access to equal pay for women who are in those states. But let's sort of look at where we are with respect to this whole concept of equal pay and equal pay days. So if you've been watching with respect to what happens for women, every year after January 1, there's a date that is set to determine what is the equal pay day for women, meaning how long does it take a woman who's doing the same or similar job to earn the same pay that a man is earning doing the same or similar job. And so what we found out is that for women in general, just taking an average time frame, that it usually takes an additional 4 months, and that's until the month of April, for a woman to earn the same as a man who's doing the same or similar job. So if we look at these gaps and what's been happening, and we look at them for purposes of the year 2020, we are looking at these recognition days, which are absolutely sad. Why can't women earn what men are earning at the end of the year? Why do we have to wait for 4 extra months? Well, that's a sad thought that we have to wait an extra 4 months. But if we look at women of color, they have to wait even longer. So Asian women, it takes them an additional 2 months to earn what men are earning. But what we're going to look at in just a few minutes is just how that applies as we take a more in-depth look at that concept. And if we look at Black women, it takes us until August, an additional 8 months and 13 days to earn what men are earning when we are doing the same or similar jobs. And we're going to look at a few more statistics there in just a moment. With Native women, an additional 10 months until October. But for Latina women to go to the end of October, almost an 11 additional months in order to earn what men are earning when they're doing same or similar jobs is absolutely untenable. And so then we also took a look at what are moms and dads. If we just looked at moms and dads and how they are earning money, we are seeing that there's a 70-cent wage gap in between what men and women are earning when they're moms and dads, and they are doing same or similar work rather. And it takes until June, an additional 6 months for a mom who's doing that work to catch up with a man who's a dad doing the same work. So all of these disparities, all of these barriers, we are looking for ways to change them. So let's take a closer look at what happens with respect to the wage gap for Asian American and Pacific Islander women. So if we take a look, we can get my fingers to work correctly there. We look at Asian American and Pacific Islander women, that they make up about 2.9% of the workforce, and that's really great, but they are also 4.4% of the low wage workforce. So as we looked at this, at the work of Asian American women, most of the women tended to be more engaged in STEM work and more engaged in technology work that made up for the difference in the pay that brought up the shorter period of time to February, when we were seeing the equal pay initiative recognition rather for them. But the problem that we are seeing is why, again, does it take an additional 2 months when they're coming to the table with the same background and skills and ability. And so we also found that Asian American women were also overrepresented in low wage industries, and these included areas such as in personal care service and in the retail area. And we were asking, why is that occurring also? So we're going to continue to look at that issue and to do more and more research in that area so that we can come up with an answer. So when we come back next year and we have this conversation, when we're not in a COVID environment, we'll have a one-on-one conversation in a room where we're talking about that. So let's look at what we did see with respect to Asian American women, even though they're making an average of 90 cents. What we found out is that there was the data that was provided was not necessarily the same for all Asian women. And so you see to my left, and hopefully your left also, that you're able to see the difference in the Asian women and the country from which their country of origin, and they may be living here in the United States now, and the differences in the pay and how that difference is absolutely affecting and causing barriers for them. And so if we look further, we see what's happening in New Mexico. We've determined that in New Mexico, Asian women are making about 83 cents to what white men are making. And if we look at what's happening in places like Alaska and Hawaii, where there are large populations of Asian women, we see that sometimes they are earning only 54 cents to the dollar for what men are earning. And in Hawaii, if we look at that, what we're finding is that over a lifetime period, about $764,000 is what Asian women are not getting just because they happen to be women. And so why is that an important issue? Well, the biggest issue about that is it has to do with retirement. So if you look at your retirement pay when you have been working for a number of years, and if you have been at the low end of the pay scale, your retirement pay is going to also be at the low end of the pay scale. And so what does that mean for you? That means that during those days when you should be relaxing and enjoying time with your family because you have put your time in for work, you are not getting the amount of money that you should be so that you can enjoy the life that you are entitled to have simply because you were a woman and you were not being paid what you should have been paid. And so what we have been also finding out is that unions have been helping Asian women to get equal pay. And then when they were able to unionize, we found that they earned at least 11% more a week than women without union voice. So we're going to look a little bit closer in terms of what were those types of jobs and how did they come about that the unionization of them helped Asian women more in terms of an 11% increase on a weekly basis, because those are the things that we want to try to duplicate, but duplicate them so that they are at 100% level and not just at an 11% level. So now let's take a look at what was happening with respect to African-American women and equal pay. As we looked at this aspect of African-American women, we found a couple of things. Number one, African-American women were experiencing a form of discrimination, not only with respect to the income that they were receiving, but also based on race and gender. So there was a race and gender a gap that they were also bearing on their shoulders in addition as they work and provide great benefits for their employer. And so we saw the sharpest distance or the sharpest earning differences occurring between Black women and white men, but Black women also had these disparities when compared to white women and Black men. So something is absolutely wrong here, and that something needs to be changed. And we keep telling women over and over and over again, you have the voice of the power of your vote, and you should only be putting people in office, and this is not a political statement, that will support women and that will support you and the work that you're doing and making sure that you're treated fairly. So regardless of their occupation, education, or years of experience, we saw that Black women were still just not being paid the same as men. Hopefully there's a woman who's going to be the Vice President of the United States very soon, not hopefully, she will be there, so that she will be looking forward to and bringing legislation and voting on it to the floor of the Senate, that, like I said, that's been sitting out there for more than 6 years, that will bring that equality for women. And also looking at these great disparities that we're finding with women of color. So the African American Equal Pay Day, 8 months, 13 days compared to 12 months for a white non-Hispanic male. That's got to change. Let's continue to look at some other statistics that we found as a part of our work. So we found that women of color make up about 35% of the workforce of women in all of America, and that we found that about 59% of the number of Black women own businesses, that they increased from the year 1997 to 2013. So what would have caused that? So we saw more and more women opening their own businesses over a variety of areas. And this was a great thing. We liked that a lot. So then there was no more disparity in terms of what your pay was, but the question is, were you getting the same access to financial resources to make sure that your business was operating? So that's another conversation, but that one is not a part of our conversation today. And so if paid equally to the average American woman, we still are seeing that the average Black woman would earn almost $950,000 more over the life of her career if she were just paid fairly. So we also then wanted to take a look at education, and is that a catalyst for change and for making sure that women are paid fairly? Well, what we found out is that higher education is often a great prerequisite for success, and those things often gave you the leeway and opened the door for other professions that you might not be able to have without that educational training. But we also saw that with respect to Black women, that they often had higher student loan debt than others. And as an undergraduate degree, they tended to carry about a $30,400 debt compared to white men who only carried debt for about $19,500. How do you figure that? We're still working on it. So then let's look at economic security. So let's see if we can go forward and not backwards. So as we looked at, I'm not sure why I'm going backwards, so there's something there. So as we look at, let's just move on to job markets, for example. So we found that Black women were making about 79% of every dollar that a man was making, for an average annual salary that was about but about 40% lower than what white men were making. So we need to figure out how do you get employers to take these implicit bias tests to determine, so to help them determine that they are making decisions that are based on the fact that these are women who are doing the job, who may want to take off every once in a while or need to take off to take care of their families because of the a family initiative or item that is occurring. And so what I did and what we did is we found that there were some conversations that we had with women, and as we talked to them, and they would go and ask for more money for the work that they were doing, then we often heard employers giving responses like, "Oh, I can't give you any more money. We have to give John more money. After all, he has a family." Well, what about the woman? She had a family too. But in any event, those were some of the excuses that we heard. And unfortunately, that was a barrier unless a woman was ready to bring her action to talk about why she wasn't paid fairly. Then we look at high salary positions. We saw a big difference there in terms of what those amounts would translate into fair pay and equal pay. And there was often a huge disparity there also. Now, what about Native American women? What did we see happening with them? We see them galvanizing and coming together and saying, we're no more stolen sisters, and we like that because we're women who are here and we're working. In my conversation with talking with Native women, what I would find out, many times they would be offered an amount before they started a job, and the day that they walked into their employer's office, they found that they were not being paid that at all. They were being paid something different. But in many instances, they were often really happy to have a job, so they didn't argue and fight because of what was occurring. But the fact that there was a paycheck that was coming in to help the family was solace for the moment. And then as we look at the pay gap for Native American women, it continues to widen regardless of how much education we saw the women coming to the table with. And so again, we sincerely believe that every single employer needs to take an implicit bias test so they can see exactly how they are making decisions and how that implicit bias is influencing what they're doing. And with respect to Latina women, what did we see? We found that over a 40-year period, that Latina women are losing $1.1 million. And this cost them about $28,000 a year, which is basically what a person could be paid who's doing a job that was equal to a $28,000 job, and they're being punished with that simply because they are a woman and not being paid fairly. And so we found that they must work 22 months to earn what men are earning in 12 months. So remember, we saw them going 11 months just to sort of get to the point where they were getting paid equally. But when we saw every single Latina woman being put side by side, it really takes them about 22 months to earn what men are earning in just 12 months. And so with respect to equal pay, the key to equal pay with respect to what we've been seeing Latina women doing is going on to podcasts and social media, talking about how do we stop this inequity. There is an organization that is a nationwide organization called Equal Pay Today, but which KWH Law Center is a part of, where we are galvanizing women around the country to come together to make sure that we are creating the strategies and we're having the conversations to put an end to these disparities that we are finding that are going on. Now, one of the things that we did notice with many of the states that do have some sort of an equal pay law in place is that there is an exemption for small businesses, so that if an employee is working for a small business, however that is defined within that statute, then they are exempt from the provisions of the application of what would be considered the fair pay for act in that state. So here we are, and we are still looking at trying to find equal pay for undervalued, underpaid, and undersieged women. So I want to tell you very quickly, and we will have time to get to those questions and answers, about 3 cases that I want you to know about. The first one was Morgan versus the United States Soccer Federation. So that was the case where women on the United States soccer team were saying, hey, we're not being paid the same as men, and we want to have the same opportunity to get that pay. And they took their case to court, and the judge looked at the evidence, and he looked at what was presented to them, to him rather, and he said to them, you know what, ladies, you chose to have a different way in which you were going to be paid than the men chose to get paid. So if you had chosen the same contract mechanism, then you would have gotten more money. And so because you chose to negotiate the way you did, then I don't see any difference in equal pay. Well, the women said, we don't like that at all. And one of the things that I did notice, and that we noticed that occurred after that, there was a tweet by our now president-elect, Joe Biden, and he said, if I am elected president, and this was before he was elected, he said, I will make sure that the women's soccer team is paid fairly. So ladies, we're gonna have to hold him to that. We heard him say it, we heard him tweet it, now we're gonna watch it. But this is a case that we lost, and this was the case in 2020. Let's look at another case that has occurred. This case occurred in California, and it's the case of Rizzo versus Yavino. Now, Miss Rizzo was a well-educated woman who went to work in Fresno, California, and she was teaching a number of classes, and she found out that she was not being paid the same as a man when they both started at the same time. She started at a salary, and at a step 1, he started at the same salary, but at a step 9. So when I say same salary, the same salary range. And so she said, that's not right. Well, when you talk to the employer, they said, well, we looked at we had a conversation with Miss Rizzo, and we asked her what she was making, and we gave a nice increase over what she was making before she came to work for us. So the basis of her lawsuit was that you should not be able to, that meaning you meaning an employer, should not be able to talk about my prior salary for purposes of the job. You need to pay me what I'm worth at the moment that I walk through that door. And if there's a man who comes through that door and doing the same or similar job, and he's hired to do that, then you don't pay us differently. So that case went all the way to the Supreme Court, but something really strange happened. Before the case could be certified, and before the Supreme Court before the decision could be certified, rather, one of the justices on the California Supreme Court died. And so the question was whether or not the case could be certified based upon the decision when a justice wasn't there. So indeed, once a new justice was replaced on the court, the same decision occurred. And that decision now stands in California. You do not discuss prior history when you work to hire a person. And then let's look at what's happening in New Mexico. So in New Mexico in 2013, we passed what was known as the Fair Pay for Women Act. And so we were really happy. Women were galvanized, we came together, we got this Fair Pay for Women Act passed. And what was really good about that act is it excluded that 4th provision. Remember that we talked about at the beginning of this presentation that employers could make a differential decision for purposes of pay on any other basis other than sex. And that was always a pushback, a barrier many times for women winning when they went to court. So we were able to get that bill passed, and that bill passed and signed by the then governor of the state of New Mexico. But then the state said, well, we're not going to honor that for purposes of women who work for the state. And the reason that statement was so important is because the first few cases that were filed under the Fair Pay for Women Act were cases by women who worked in state government. And the state government offices, primarily the Department of Corrections, said, you know what? Number one, we didn't agree to, the state did not agree to be bound by that. And under the Tort Claims Act, we're not going to be bound by it. And anyway, we have immunity, so we will not be bound by it. Well, the women said, yes, you will. There's no prevention, no way that you should be prevented from having the Fair Pay for Women Act applied to women who work for governmental entities, particularly when you look at our state, because our state has the highest number of employees who work in a governmental entity environment. And the number, and then you look at that even closer, you're looking at a huge number of women who work there. So we're allowing the federal, would we allow the state government to say that, yes, I can be excused from a Fair Pay Act simply because I'm the government? Well, the Supreme Court actually it was the Court of Appeals who first said, no, you are, that this law does apply to you. When it was appealed to the Supreme Court denied cert, so the decision stands today. And what's really great about this case is there's a woman named Alicia Tafoya Lucero who brought one of those cases. And if you recognize that name, Miss Lucero is the woman who sits today as the Cabinet Secretary of the Department of Corrections. So what that means to us is that she's looking out for the other women who work in that division, that department within state government, to make sure that they are being paid fairly. So men and women are walking side by side in lockstep under her direction and being paid fairly. So I'm going to hurry so that I can make sure that there's time to answer your questions. In COVID-19, we're also, I just want to bring this to your attention, we're seeing this disparity that's occurring with respect to women and pay. A lot of women are on the front lines and they are showing up. They are there at grocery store clerks, other places that were considered essential, healthcare workers in many cases, but they are not getting paid bonuses and they're not getting paid fairly and well for the time that they're putting their lives on the front line. And we want to see them absolutely get paid fairly. But we also find that they are the ones who are getting laid off first. For example, if they worked in dry cleaning positions and other provisions that were not considered essential provisions during the COVID impact shutdown to make sure that we're all kept safe, then they were the first ones to go. And they're the ones who are being affected by attempts for evictions, for example. And if we look at the households that are in the state of New Mexico, with about 46% of them being headed by women with children, and they are being the first ones that are being laid off, we have a problem. Right now, the Supreme Court is not enforcing eviction proceedings. They're allowing eviction hearings to go forward, but not enforcing them. So what happens when that restriction is lifted and all of these women, if they haven't been paid and they are not being paid, they're being laid off during COVID-19, how are they going to be affected? We need to be on the lookout for that and be ready to help them. So as we move forward, we see that there are a number of areas, 5 of them that I have listed here for you with respect to contributing factors for pay inequity. And I want you to, as you continue to go throughout your day, throughout your year, and if you are in a position where you're hiring people and you're making decisions about what they are making, what those salaries are going to be, make sure that you are weighing carefully everything that you're doing and that your decisions are being based on a fair and equitable manner. So when we look at these court cases, we saw them going on, we saw what was happening with them, but we saw what was happening in New Mexico, and we saw the big movement that was happening here in our state. We're happy for that. We are happy that that law was tested The best thing that can ever happen for an advocate is to have the legislation or the policy that they wanted to have implemented, to have it tested, and to have it be successful. So now this is the moment that you've all been waiting for. What are the new strategies that we need to put in place going forward, not only in this state, but around the country, to make sure that we have women getting paid fairly? So let's look at those 5-point strategies. I want you to pay attention closely, write them down, because we are going to galvanize women around the country as we walk together to make sure that women are paid fairly. So here they are. Let's look at them. First of all, we're going to go state by state. We're going to look at these strategies. We're going to reach out to your friends, to your family members in other states other than where you are. We're going to start looking at those equal pay bills and looking at those equal pay acts that are on the books of the states right now. Where do they need to be strengthened to make sure that women are paid fairly? So this is a state by state, a 50-state strategy, because we're headed toward the Capitol in Washington, D.C. as we implement this 50-state strategy. And as we look at right now, if we're looking at these states across the United States, we're showing where there's gender-specific legislation that is absolutely in place. The red areas are gender plus other protected categories that are in place. And where you see the stars on the map, these are places where the salary history inquiry is being banned. And those are the things that we want to have stopped. So where you see those light areas, you will see that there is no specific area. There's no specific pay equity law in place there. So the next thing that we want to do is that we want to make sure that in every single place, in every single state, that for sure there's a legislative success to prohibit prior salary discussion. So if you're already not being paid fairly and you go in for a job and they say, how much did you make? And they said, okay, well, we're going to give you 15% more than that. Well, if you're getting 15% more than that, but you're 30% less than what you should have been paid, you haven't really made progress. So we want that to stop, and we want women to be paid what they should be paid. So we also want to make sure that the legislation that is sitting on the Senate floor right now, that has been sitting there for far, far too long, is absolutely acted on, voted on, and implemented. These acts have passed the House of Representatives and have been sitting unnecessarily on the Senate floor and depriving women of the fair pay that they deserve. One of which is the Paycheck Fairness Act on a national level that does away with that fourth provision of the Equal Pay Act to strengthen the Equal Pay Act even more, so that there would have to be many more steps that would have to be taken if you're going to use some other mechanism other than sex to make a difference in terms of paying men and women differently. That Paycheck Fairness Act needs to be number one on our list to make sure it gets passed. The other thing, and the last of these items that we want you to remember, is that the American Association of University Women, and yes, I do sit as the state chair policy for AAUW, we provide a session on how to negotiate your salary. So ladies, I want you to take a moment, go to aauw.org and take a look at that platform and make sure that you are also negotiating your best salary. Don't settle for anything less than what you are worth, and you are worth a lot. So we are looking for you to take hold of that and also help us as we help you to get paid what you should be paid. So together we can take actions to address systemic inequity, and we want to close the wage gap and the opportunity gap that is often a barrier to women and barriers that should not exist. So we want you to join us. We want good brothers and all of the sisters to join us as we continue to fight for women and girls to receive equal pay. And we will be able to overcome these pay inequities by, of course, learning how to negotiate your salary, fighting for good laws on the books, getting them implemented, and voting for people who will make sure that you support, that they support fair pay for women. So, we thought about this idea in the month of March. It's called Women's Equality Month. And during that month, it's called Women's History Month. So we were looking at Friday, March 26th from 12 to 1 to have a Twitter, Facebook, virtual gathering, assuming that it's, and a in-person gathering on the steps of the Capitol to say, we want equal pay and we want it now. So we're gonna be tweeting, doing Facebook. We're gonna have that virtual rally if we can't get together in person, but we are coming together as women around the country, and we want to say, pay us now and pay us fairly. So we no longer want to be undervalued, underpaid, and under siege. We want solutions for our equal pay. Here they are again listed so that you can remember them. All of the items we talked about. The one that we missed is we want to make sure that law firms, we want you to step up and help us, because we are concerned that there will be cases affecting equal pay that will come before the Supreme Court, and we're going to need your assistance. When I say we, I'm talking about nonprofit organizations. We're dependent upon you to help us with those amicus briefs and to fight those issues when they come before the Supreme Court. So with that, if you have any questions, we have about 5 minutes. Asia, where are you? Sonia, who's gonna ask those questions? Where are they?
I'm here. Thank you. Thank you so much, Ms. Herndon. That was amazing. We appreciate you. We appreciate you. Our first question is, how would you, sorry, let's scroll down. How would you address the difference in bonuses between men and women in the same office as it relates to the same stats concerning productivity, race, motherhood, et cetera, especially when shareholders and partners prohibit associates from asking what others make?
So that is, thank you for asking that question, whoever put it in. One of the other items that we didn't talk about today that we're looking at is preventing employers from stopping individuals from talking about their salaries. So right now, you could actually be fired in the state of New Mexico for talking about your salary. And we want that to stop. And if you look at bonuses, bonuses would fall into that same line as, remember, under an Equal Pay Act, there is the merit provision. Well, that's what those bonuses are basically like. So we want you to be able to talk about your salary, what you're doing, talk about it with your colleagues, and be able to have that open discussion, and then have it with your employer and say, look, if we look at these things side by side and we put them on the scale, we are way the same, and you are not giving us the bonuses that we are entitled to receive. So that is also on our agenda. I want you to know about it, and thank you for raising that question.
That was a great question. Ms. Herndon, I, along with I'm sure many, have been noting the fact that the report showed that in September, 4 times as many women dropped out of the labor force as men, at a rate to an amount of 865,000 women dropped out of the labor force. And many are attributing that to the lack of childcare or the schools closing down. What can be done to protect women's productivity, salary earning potentials when they're able to re-enter the workforce?
So
through this period.
Thank you again for that very excellent question. So when women come back into the workforce, remember at the beginning of our conversation, we talked about the seniority concept, and that how women are often hurt by that loophole that we see, for example, in the in the Equal Pay Act of 1963. Unfortunately, that provision also exists in the New Mexico law. So what we want to have happen and to strengthen that is that when women take off to take care of a family member or to take care of a sick child or even for themselves, that they don't lose that seniority aspect of their work because of the health care that they are under, and making sure that they are taking care of themselves and others. So that's still something that we're going to have to maybe litigate and to fight for, because that seniority aspect is still going to be what is on the books on both the state and the federal level at the moment. And we are trying to find a way to make sure that people are not hurt by that. And that is exactly what happens when women leave to have, when they're pregnant and they leave to have a child. But it doesn't happen necessarily with respect to men, except for one instance when we see men taking off if they want to take if they want to take parental leave, for example, if their employer allows it. Sometimes they don't necessarily advance at the same pace at which they had if they had stayed, but that should not be a barrier. We don't want having children and childcare to be a barrier to your advancement. We want it to be something to support it. So that's something we're going to have to overcome. You did point it out, and we do recognize it is a problem.
Thank you so much, Ms. Herndon. We absolutely appreciate you, and thank you for your time this afternoon. I now turn it back over to our president, Ms. Asia Brooks.
Thank you. And being a new mom and a woman, I am so happy for Pamelya Herndon and the work that she does, you know, and multitasking and doing all of the things that you need to do. It's so important to have fair pay for women. So he would not let me put him down. So he's going to be in the video. But I just want to say thank you for your work. And thank you for your presentation. Thank you everyone for staying with us for today's presentations. If you were here for yesterday's and Wednesday's presentations, we thank you for supporting the New Mexico Black Lawyers Association. I'd like to say again, thank you to our co-sponsor, the City of Albuquerque Office of Civil Rights. And a special thank you to Crystal Velarde for her technical support. I'd like to thank all of our speakers. This has been an awesome CLE series. I'd like to thank our New Mexico Black Lawyers Association board, Tori, Vinay, Dominique, Sonia. Thank you so much for all of your work. I always have to give a shout out to the founding members of our association, Raymond Hamilton, Tommy Jewell, and Hannah Best for creating the association back in 1982. Also, a special announcement, we will be unveiling our New Mexico Black Lawyers Association YouTube channel on Saturday, tomorrow. Thank you to Sonia and her daughters for working on that. It will have all of the presentations from the Social Justice 101 Lunch and Learn series. So they will be available there. If you have not sent me your bar numbers yet, please send those to me so we can go ahead and get you your credit. But other than that, I just want to say thank you. We hope that you will join us again next year. We do a yearly CLE, so we're hoping that this was interesting for you and that you'll join us again next year. We appreciate your time and thank you.